Good evening. This is a meeting of the Athens Board of Zoning Appeals. The time is 7:01 p.m. and the date is October 10, 2017. At this time, I will call the meeting to order. The board consists of 5 members and 2 alternates, the alternates taking full part in the discussions and becoming a voting member in the absence of a member or when a member abstains for conflict of interest. Present tonight are members Ms. Kate Housley, Mr. Ed Baum, Ms. Lisa Carson, and our alternate tonight is Mr. Aaron Thomas, who will be a voting member. I am John Golsey, the chair. Also present are zoning administrator, Mr. Rick Sorois, and secretary, Mr. Paul Eschenbacher. At this time, I invite you to view a pre-recorded video on the rules and procedures of the board.
The Athens Board of Zoning Appeals operates according to the following procedure. The chair will name and describe the case. The zoning administrator or secretary will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or their representative will offer concluding, summary, or rebuttal remarks. Testimony from the floor shall be closed. The board will deliberate and render a decision. According to Athens City Code, Section 23.07.03b, the board has power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest. The spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to Athens City Code, Section 23.07.10c, variances from the code shall not be granted unless the board makes specific findings of fact based directly on the particular evidence presented to it, that the standards and conditions imposed in this title, if applicable, have been met by the applicant. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone and the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which variance is sought, one or the other, or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. Any person, resident, or officer, department, or appointed body of the City of Athens, aggrieved by a decision of the Board, may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the applicant. Thank you.
The board also has the power to review decisions of the zoning administrator where an error is alleged, and we have one of those cases tonight. There are two cases on tonight's agenda, and they will be heard in the following order. Case number 1723V, property at 96 North Congress Street, and case number 1724I, property at 319 West Union Street. The board is required to take testimony under oath. Would anyone wishing to speak concerning any item on the agenda please stand? Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Be seated, please. Do we have the appellants for both cases?
Yes.
Okay. Case number 17-23V, property at 96 North Congress Street. A zone is R3. Les Cornwell is the appellant. Appellant is requesting variances from ACC 23-1001 Table A, a schedule of bulk controls to allow the remodeling of a structure from 2 units with 8 total tenants to 1 unit with 5 total tenants, with a front setback of 18 feet where 25 feet is the minimum requirement, a left side setback of 2 feet where 4 feet is the minimum requirement, and lot coverage of 45% where 30% is the maximum allowed. Also from ACC 23-1001 Table B, off-street parking requirements to allow 0 parking spaces where 5 parking spaces is the minimum requirement, and from ACC 23-03-10 to have 2 principal structures on 1 lot where 1 principal structure is the maximum allowed. Yes, sir.
Since I was the one who handled the permit application, I'll try to explain it. Basically, what they wanted to do is they had a house there that was a duplex with 2 units and 8 people total, and they wanted to reduce it to 1 unit with 5 people. But because of our interpretation of the code that any changes means that the property must come into complete conformity, that's what set up all these variance requests. In reality, they aren't changing the outside of the house at all. It's all inside work, so all these existing things, the 18-foot front setback, the 2-foot side setback, the lot coverage of 45%, the 0 parking spaces on site, and the 2 principal structures are all the same. Mm-hmm. It's just that they come into they have to be listed as the nonconformities that they have to address. So really the only change is they now need 5 parking spaces where before they needed 8.
Okay. And has any part of the work been done already?
Yes.
Okay. What, is it completed?
I'm not sure if it's
Okay, well,
completed. I
fine.
know they've been working on it. You can ask the appellant's rep, but
Okay, would the appellant or the representative please come to the podium and state your name, address for the records, and your case? Yes, I would.
My name is Shelley Baker. I work for Les Cornwell. I've been with him for 3 years. And unfortunately, this was my very first code experience. It has not been that fun, but I've learned a lot. So I'll give you a little history. I went to the code office to ask for guidance in what to do so that I could follow the rules correctly. I filled out my first application on 8/26/2016. Okay? I got an approval 8/30/2016. So at that time, I said, is there anything else I need to do? I'm good? I'm good to go? Absolutely, you got an approval. Got your approval. I got a call to the office, or to the code office, from the code office saying that I needed to change a couple of things on the application, and could I please stop by to do that? I went there directly, and you can see from application 1 to application 2, dated August 29th is the first one, 10/4 is the second one. That's when I got the call to come. I had to change the check box of the rental unit. I had put 2 numbers of units, and it in reality needed to be 1, because that's what I wanted to change it to. And that I was going from apartment A had 4 tenants, apartment B had 4 tenants, and I had to put 5 tenants. So that was the change I had to make, okay? So then I submitted that, and I got another approval on 10/21/2016. Again, am I okay? Are we good to go? Our upstairs apartment was not rented at that time. So the only thing we were doing upstairs was removing the kitchen. So we removed the kitchen because we had no tenant there, because I had 2 approved applications or certificates. So then when summer rolls around and the tenant at the bottom floor leaves, we remove a wall. It's not even a wall. It was covering the staircase because they could go out the side door, but we opened up the entryway that connected the house. We removed that. Now we have 5 bedrooms. We rent it. We have rentals. We have people there. Then on 1 year later, 1 year, almost to the date, I received a call on August 24th. My first approval was August 30th of 2016. August 24th, 2017, I received a call from the code office that I did not have the appropriate paperwork, and there's been a problem, and I needed to come and fill out another application because I had been denied. I flipped out, and I was like, oh my gosh, I've done something wrong, because again, I went to them multiple times for guidance on what to do. I'm like, what didn't I do, and for whatever reason, I don't know. So I was asked to fill out another application. So I did that, filled it out, and I just didn't understand what I did wrong. So I asked for a meeting with the code officer and he tried to explain it to me, and everyone's been so nice and wonderful, but I just don't understand those terms, unfortunately. I have a hard time understanding them. So I obliged, and I did that. I filled it out. And so then I had to write a letter about how it's hardship. Well, at the time, I just was so upset that I had done something wrong or whatever. I didn't do something right. So it didn't make any sense. And I then got a refusal on. The refusal was then on. My refusal was on 8/28. Okay. So then they tell me I have to pay these fees and fines and come here. So then I gather all my information, I go to there, I gather everything they have, and I start reading through. And then I see that they get an email from someone that is contesting this on 8/23. Okay, saying that we had an increase in occupancy in residential zone, but we had a decrease. We went from 8 to 5. Mm-hmm. And so I hadn't even been refused at all. So why did I fill out these paperwork again if I had not been, I had not had a refusal till the 28th. So that's where we are. And we have it rented for the next 2 years, and it's beautiful. It looks beautiful. We've increased, it's beautiful. And I do all the rentals. I've tried to really work hard at making them obey code, and I feel like Mr. Cornwell's properties have really, come a long way, and we're trying hard to remodel and keep them nice, and I really try hard to put good people in there.
Yeah, I saw the outside looked pretty good
Yep.
compared to the rest of the houses in the neighborhood. And these are good experiences for you, so next time you know.
Yeah, no,
Yeah.
and I
Well, I'm
can't
not
say
too sure
enough
about
good about code. I mean, they really have been
Yeah.
wonderful.
You mentioned that there was a fine in addition to the fee you had to
Well,
pay?
I had to pay a 75 and a,
Well, that's just the fee.
It's just the
Yeah.
well, see, I don't know what I'm
But no
talking,
fine.
yeah.
Okay,
Not fine,
Okay,
Okay.
it felt like it.
I know.
Yeah. And we don't get any of it, so.
Okay.
Okay, you may be seated if you have any questions. Is there anyone who would like to speak on behalf of this?
I need some information.
Oh, I'm sorry. Could you go back over there for a second?
Not from her.
Well, yeah,
I do
just,
too, I need to ask Paul something.
yeah. Let me first ask if anybody else has any questions from the appellant. No?
Not at this point.
Okay, you can maybe seat it. Go ahead.
I'm just wondering, what happened in the year between the first approval and then the second seemingly disapproval?
We went under the interpretation of the law about changes, that if they reduced both the number of units and the number of tenants, that would be acceptable and they would not have to come into complete conformity. In the meantime, what happened was, unfortunately, Mr. Linder's case down on West Union, where he tried to put in 2 parking spaces that was refused because he did not bring his property into complete conformity. We were then told that the proper interpretation, and you guys reviewed this interpretation, that if a place is non-conforming and they're changing it, they have to bring it into complete conformity. We were not operating under that when the first 2 rental permits were accepted and approved. Otherwise, if we had been going by that at that time, back in the spring of 2016, the rental permit for 1 unit and 5 people would have been refused. But at that time, we thought it was okay to approve it because they were reducing the nonconformity of the property. Since then, because the interpretation from Service Safety Director's office and the interpretation of the zoning board itself, that no, they have to come in complete conformity. So Cornwell's properties just got caught in bad timing. We approved something and then were told in the meantime, no, that was incorrect.
Okay, thank you.
Any other questions?
Yeah, I just had a question about the 2 approvals that we have from 2016. One of them, the earlier one says there are 2 parking spaces and the later one says there are 0. But is 0 the correct number? Okay, thanks.
That's what I was called back.
Yeah.
Anyone wishing to speak in favor of the request will be heard now. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. Mr. Pearson, please come to the podium, state your name and address for the record.
My name's Steve Pearson. I live at 7520 Lee Master Road, Athens, Ohio. I'm acquainted with Ms. Baker and just talked to her today because she was having trouble understanding the process that occurred in this case, having been given approvals in the past and then recently being denied the permit. I've been a zoning official for 23 years now. That's ended. But my experience, and I argued this in the reference case that the case was just made reference to, that administratively you could look at a property where you're decreasing a nonconformity, and you could have an administrative policy that allowed that without appeal. So, for example, in this case, the number of units is being reduced, the number of tenants is being reduced, and there's no other change in the property. To be real honest with you, I really don't understand why that would take a review of the board. I understand that's the current policy. But for example, somehow or other, this change has kicked in. So is it change for more, change for less? See what I'm saying? Just this general comment of if it changes, everything has to conform. Let me give you an example, and I'm going to use this example probably in the next case too. I'm in a business zone and I have retail sales and I sell clothing, let's say. I decide I'm going to change my business and I'm going to sell sundries. I'm going to sell pop and chips. Is that a change of use? Well, it's in a retail category. Do you really go to such an extent as to say it's a significant enough change to kick in a review of all the nonconformities the buildings
Is this
might
for the
have?
second case or this case?
I'm presenting for the first case, but
Okay,
referencing for the second also.
okay.
There was no other change made. The building's not being expanded. There's no construction work going on. And so administratively, and I guess it's a reference too, that's not the policy anymore, but I'm advocating for that again, for
Okay.
another review of that. If you have voluntary reduction of nonconformity, and I feel kind of bad for you, look at this long list of things you have to look at and grant variances. You have to go through findings for variance on all of these. That's why administratively it'd be easier just to let this go if there's voluntary reduction in noncompliance. Also, in the definition of nonconforming use, it says bulk controls are grandfathered essentially. It's just when you change uses from a use that's not permitted to another use that's not permitted, that's when, well, let me back up just a second.
I am a bit confused. Are you opposing the appellant in this case, or are you opposing the process that exists right now?
I'm advocating for the appellant.
But he had asked for people opposed, and you stood up.
No, I said general comment.
No,
No, he'd already
nobody
passed
was.
that.
This was for the opposition.
One of the board members acknowledged that I raised my hand when you said general
Oh,
comment.
okay.
Coach
But
Evans, yeah.
this side of the row was confused.
Okay. Sorry about that.
Okay.
So, I guess what I'm saying is, there's really no reason to be here to do this. Yes, I would advocate, that this be approved. You got a long list of things to go down through here, to grant variances for. But the code actually says the definition of nonconformity does not include height, area, yards, courts, or distance requirements for more restrictive zones or uses when a use is permitted. So I don't see where there's a nonconformity that has to be reviewed.
Right. Actually, I made a note in here which I was going to read, and you beat me to it. That I was going to discuss
Right.
exactly the same thing. I will talk about
And
it.
again, there's been allusion to that. It's an administrative policy, and I grant you that. It's an administrative policy.
Right.
How you want to view these kinds of things, but it just seems like there's an awful lot of cases that the board will have to hear or has heard where this could be handled
But
administratively.
I don't think we are the body that can make that decision.
You haven't been asked for interpretation. We'll do that on the second
Okay.
case.
Okay.
Thank you.
Thank you. Anybody else? Would you like to say anything more? You have a last chance
Yeah,
to the podium, please.
Yeah, I do have one quick question. When you said because of something that changed, somebody's case changed, so did you go back to anyone in the last year and then deny?
Not went back and denied, no. You were just caught between two different interpretations. When you handed in those rental permits last year, those were okayed because of what we thought the interpretation was. By the time we heard other cases and realized that now the official interpretation from the city is that you have to come into complete nonconformity. And also changing the inside from 2 units to 1 requires a basic building permit.
So
So
after
that
the
was
work's done,
refused.
so
Yeah.
after the work's done, you can go back and say, oh no, now we
Well, yeah,
are
I mean,
deciding.
if somebody falls under the category of doing significant enough changes that it requires a building permit or a zoning permit, yes, even if the work is done.
If I may, do you remember I sent you an email saying when someone had pointed out that work was being done?
Right,
You
yes.
got that?
Yeah,
That's
on
what
the
that was all.
23rd. Yeah, on the 23rd,
Yeah,
that
that
was,
was also part of what triggered it.
right.
So we had to respond to that also.
Okay.
I just find it, I think that, you've invested time and money in this property and already have it filled, and I don't think it's right, but I'm not here to judge or decide, I don't think it's right. So,
Thank you.
thank you.
Thank you.
Could I add one more thing too?
Yes, sir.
Because it's been alluded to another case that Mr. Leonard and I were involved in previously. As you remember, the result of that was we came in and asked for a substitution of nonconforming use, as opposed to going through this giant laundry list of all these nonconformities. For a substitution of nonconforming use, which I believe would have been the better way to handle this situation, there's only one finding, and that finding is there less detriment involved with the proposal than there was with the existing condition? One very easy finding. But it wasn't denied for that. It was denied for all of this long laundry list of things. So that's another thing that you might want to consider from the case Mr. Linder and I presented before. A more appropriate way for the board and a little simpler way for the board to handle this would be a substitution of nonconforming use. That review is pretty easy. The findings are pretty simple. Thank you.
Thank you. We're going to close the discussions from the floor, and unless there's any discussions, we could maybe entertain a motion.
I move that the property at 96 North Congress Street be granted a variance from, and I'm not going to read this whole thing, or do I have to legally read the whole thing?
Do you intend to make any changes in the
No,
wording?
it'll be exactly as printed.
Then, as far as I can tell, that's okay.
Okay.
Here's your chance to read the whole thing.
I second.
Okay. We have a motion by Mr. Baum and seconded by Ms. Kate Housley. Let's go through the findings, or do you want to discuss it any further? Let's go through the findings. Usually we go to the special circumstances, but I want to go to the hardship and practical difficulty, and also addresses the general nature of this case. As Mr. Pearson said, there are many properties in this town that are grandfathered, and they don't meet the code, but they can continue as they go. Now, a property owner comes forward and wants to do something good for the property and the tenants. They want to improve it. They spend some money on it. And in this case, they're actually reducing the tenants and the parking requirement. So once the job is done, if you look at the property, do we ask ourselves, is this better now or before? Mm-hmm. And if the case is better, I think this should eventually be approved by the administrators, you know. So my question in here is that how can this be changed? What is the process? Do we go to the city council, or what is the process of saying that if a property is not a major project, there's not major changes, maybe this thing should be done automatically? So by not approving this variance, I think we are creating a hardship for the appellant, which is not necessary.
Right.
And further, I suggest that maybe this should become automatically so the code office can handle these things.
The way they had been doing.
Huh?
The way they had been doing prior to the Mr.
Yeah,
Linder.
yeah. Well, actually, I don't recall doing a whole bunch of those. I don't think they were doing it, because we have had a lot of cases coming to us for the same similar situation. They may have done a few, but I don't think they have done it as a routine, because we get those cases here. Mm-hmm. But anyway, I'd like to know what the process is, so for us or for somebody to go to the city council and say that, or planning commission or whatever commission, that for such a cases, especially when they are trying to improve the property for the, otherwise this property is going to get old and old, and there's not going to be any improvement. And by the way, once you go through this process, all those codes kicks in. So when I initially looked at it, I said there's a lot of variances, but they all kick in, you know, so automatically. And so in that case, I wouldn't consider this a maximum variance, this is minimum variance. So that's my case for the hardship.
I agree.
No, I do too.
And
Okay.
this is gonna be more prominent over the next 10 years with all the older property in town. So, I mean, this is something that probably need to be looked at long term.
As
This
far
is-
as the, yeah, I'm
This
sorry.
is like second or third case with this same issue.
Right. As far as the special circumstances, I was on that street. There's apparently plenty of parking. I was able to park. There's no meters in there. And this particular property in that particular street seems to be that the setbacks cannot be changed, you know, so I think it does apply this special circumstances. Do you all agree?
Yes.
Okay. Then we're gonna go to preservation of equal property rights.
Same as everybody else on the street.
Minimum variance.
Yep.
I think it is minimum variance despite the fact that there are so many in there. Absence of detriment
No.
and not of a general nature. I guess it's becoming a general nature, and I will follow up on it and see what exactly we could do to promote what Mr. Pearson also talked
Good.
about.
Good.
So, are we ready to vote?
Yes.
All in favor of this variance, please raise your hand. Okay, you have the variance 5-0. Okay. But next time we see you in here for the same case, that would be different. Okay, we're gonna go to case number 2. John, would you like to join us?
Yes, sorry, my 9-year-old father has conditions in the hospital, so.
Yeah, we have our second alternate member, Mr. John Goodikins is here, and he's gonna join us. Okay, case number 2 is an interpretation, case 1724I. The property is at 319 West Union Street, zone is B3, and Mr. David Funk is the appellant. The appellant is requesting an interpretation from the board that there is a change of use from residential services for special needs individuals to drug and alcohol recovery services. Code office, would you like to add anything?
I refuse this one too. Based on Athens City Code 23.04.07A4, which lists that the change from the hospital, from the building's old use to the current use is indeed a difference in use. That's where all the different bulk controls came into effect. The reason why I considered there to be a difference in the uses was the actual section itself, which differentiates. And also on the permit that was handed in by the appellant, Mr. Funk, he differentiates because it says current property use, residential services for special needs individuals, and proposed property use, recovery services. So even the appellant himself made a differentiation between the two. Also today, which I handed out to you, we've got a letter from the city law director about this case. If you want me to, I can read it.
Yes, please.
Okay.
This would be a good time maybe to go over
Okay.
it.
This was addressed to Paula Horan Mosley, Service Safety Director, from Lisa Eliason, Law Director, dated today. You asked me to review your denial of the zoning application submitted by David Funk for drug and alcohol recovery services to be located at the site of the Echoing Meadows facility at 319 West Union Street. The location is a B3 zone. Echoing Meadows formerly provided living, support, and medical services to clients with developmental disabilities. Athens City Code Section 23.04.07A4 provides, quote, hospitals, any hospital for human care, provided that buildings which are used for the treatment of contagious diseases and substance abuse shall be at least 200 feet from any lot in any R zone, a minimum lot area of 2 acres, 200 feet frontage, front yard depth 24 feet, side yard width 290 feet, rear yard depth 50 feet, hospitals for contagious diseases and substance abuse, 5 acres, 400 feet frontage. The proposed use falls within ACC Section 23.04.07A4 as a hospital for the treatment of substance abuse. Mr. Funk contends that there is no change of use and therefore no need to examine bulk controls such as yard setback. Mr. Funk states, the proposed facility, just like Echoing Meadows, will have a staff doctor and nurses on site or readily available, and therefore the proposal does not constitute a change of use and should not even have been considered a change of use. Because there is no change of use, all the bulk controls are grandfathered. The use of the facility will change from a facility for services for persons with developmental disabilities to a use as a facility for services for persons with drug and alcohol addiction. The persons served are not the same. The state of Ohio licenses each use separately. Thus, there is a change of use. Since there is a change of use, the bulk controls are not grandfathered. Based upon my review, your denial of the zoning application was correct.
Okay, thank you, sir. And would you be kind enough to just remind us of what the process is? What do we need to do?
Basically, you
For
discuss it, you make a motion based on what I wrote down there, and then you vote. There's no findings or anything, you simply discuss it, and when you're ready to make the motion, then you simply vote.
Now, if the setbacks, which was coded in here, was okay, then would we be here today, or?
No.
No, okay. So setbacks was not an issue.
Well, I mean, that's what kicked it into place, because this particular building does not meet the setbacks.
Okay.
Right, so.
Okay.
Here I was all prepared for an interesting discussion of what a hospital is and what substance abuse was and everything else. And now we have a statement from the law director who interprets that section for us. So I'm not too sure that we have any role left in interpretation. She has interpreted, and she is the law director of the city of Athens, that this is a change of use, and therefore the denial was correct. I'm not too sure what more we can do.
Well, we have to hear from the appellant, for sure.
Well, we can hear, but that doesn't change the law director's opinion. I don't think we can overrule the law director's opinion.
Well, then you can agree with it.
So I had a question. So this is pretty much changing the use from disabilities to substance abuse. And then through the state of Ohio, it is it the same or is it different through the state? That's my question.
Okay,
If
we'll
it's-
find out, yeah.
Yeah, that's, and that's what I'm reading from interpretation, that is different.
Yeah. That's, I think, Mr. Baum, we should hear the appellants, because I don't think she heard the appellants, right?
Well, she's the law director.
I know, but
and
she
that's her
hasn't
role.
heard
That's
the
her
case.
responsibility.
Yes. Okay, that's one opinion, and we may agree or may not agree with that. That's what we are here for. Any other questions for the code office before we call the appellant? Mr. Peterson, are you representing the?
Yes,
Okay.
Mr. Linder and I vote.
Okay, please come to the podium again. What is that light for?
It comes on and off periodically.
Again, my name's Steve Pearson. I reside at 7520 Lee Master Road, Athens, Ohio. I'm here speaking on behalf of Mr. David Funk, who's the potential buyer of the property. He would like to purchase the property to have it be a residential care facility for people with drug and alcohol addiction. The state of Ohio now has kind of an interim type facility that they've approved in between a halfway house, which is right out in a neighborhood, and incarceration. So there's this kind of this evolving state view of how to deal with people with drug and alcohol problems. That class of people is also people that do have disabilities. I mean, they're under certain disability, and they're there to be essentially in the care of the state or a service provider licensed by the state. So we would contend that even though the state might look at this in terms differently of licensing, it's still looking at these as people with disabilities. And we would also argue that they're being cared for in a hospital-type setting. People with developmental disabilities have to have different types of care, including medical care. People with alcohol and drug addiction have certain needs too, residential needs and medical needs. So we don't really see a differentiation. And we actually view both the uses as a hospital. Oddly enough, the Athens, I don't know how you would say that, let me back up a second. There are a lot of terms in the zoning code that aren't defined. And believe it or not, hospital is one that's not defined in the code. Substance abuse is one type of hospital, evidently, that's mentioned in the code, but there's no definition of a hospital. The general definition of a hospital, if you go to any dictionary, is a place for human care. And in both these situations, there's human care involved under the licensure and observation of the state of Ohio. So that would be an argument that we would make that there really is no change of use. I'll go back to my other example. Instead of saying I'm a hospital, let's just say I'm a retailer. I change and sell different products. Do all my bulk controls come into play then, especially if I'm not enlarging the building? If you can see that logic there too. Also, I'll give you another example. Could someone observe that changing in an R1 zone from a single-family residential owner-occupied house to a rental, is that a change? Well, the code calls it both uses residential, but I think there's a lot of history in town, and obviously because of the amount of rental property that there is in town, you could just as easily interpret that section of the code to say, yes, that is a change. Can you imagine every home in town that has non-conforming lot coverage, setbacks, height? So I just see this as a way that administratively it could have been determined, and obviously I respectfully disagree with the law director. The code office could have considered this as change from a hospital to a hospital because there's no definition. Another thing that there's no definition of in the code, in the local code, is special needs. I think the refusal actually said the current use was for clients with special needs. There's no, what is that? There's no definition of that in the code either. Also, there was a statement in the application too that this was being changed to a residential healthcare facility. And that's another term that's mentioned in the code. It's also undefined. So what we're dealing with here, I think, is a lack in the code of coming up to current definitions and current uses of property, especially for those people who are under the care of the state, essentially. The code's just not up to speed with it. There's child daycare centers, halfway houses. There's a lot of different issues that I would recommend the board look at and maybe have a resolution that the Planning Commission start looking at some of these things where the state regulation and actually federal regulation, fair housing and ADA considerations too, might come to mesh with the local code. I wouldn't want you to get in any kind of trouble over denying somebody's rights on a local law that might have a state or federal regulation that would override it. Let's see. Lacking definitions, and Ms. Eliason even said that there were different licensures involved. If you look at state regulations, they have skilled nursing care definitions under residential care facilities and nursing homes. There's a section for hospitalization of people with mental illness. The Department of Rehabilitation and Correction, Drug and Alcohol Rehab, they also have definitions, and they all involve some kind of residential care for the client and some medical services that might be provided. Now, each person with a disability might have different specific additional needs, but each of them has a residency need, food, shelter, and some type of medical care. So we don't really see it as a change. That's my first argument.
Okay, I have a question for you.
Okay.
Under the Developmental Disabilities Residential Center, these people were living there indefinitely, right? They were just there and they were being taken care of, correct?
Are you talking about the past
The
use?
past, yeah.
I'm not an expert in this, Mr. Linder might add some more to it, but my understanding is the facility was licensed as an intermediate care facility.
Okay.
Which meant those clients did have a potential of living independently. Now, was that a
Okay,
reality?
very good.
Was that a reality? That's up to a medical person to determine if that's true.
Okay.
The state of Ohio has recently said that these type of facilities have to be decentralized and abandoned, and Mr. Linder and other housing providers are trying to assimilate them into the community now, to integrate them into the community. So they're just,
Well,
what seemed
the
right at one time
differentiation-
now seems not to be as desirable.
The differentiation that I was gonna make, and did come up with an example for you, was that if this, initially, they were living there for a long term, for the drug and alcohol recovery, I wouldn't think it's like a long term, it's most likely short term. And the example that probably matches this is that the difference between a rental house and a bed and breakfast. You could be renting a place for 6 months to somebody, or you could have the bed and breakfast. Those are two different uses that we have established already. So in my view, based on that, I see that these could be two different scenarios, two different uses.
The original permit said it would not be commercial.
Hang on just a second.
Sure.
This is ongoing in the state of Ohio too.
I think they're right. It says right there, something. It does say developmental disabilities.
I'm sorry, I don't have a document that Mr. Linder's referring to, but what we're talking about was the original permit that the city approved in 1978, 79 for the facility that's there now. And there was notation, Mr. Linder's telling me, on that document that says that will not be long-term housing. Now, did it end up being long-term housing for people? I have no idea. So just to address the idea, is it short-term, long-term? I suppose at this point, what I would argue is, they're both permitted uses. This is gonna be my second argument too. If both uses are permitted, why would bulk controls even come into play, even if it was a change? I can understand it if it was a change from a permitted use to a non-permitted use, or something that was grandfathered for not being permitted. In the last case you heard, it was changing from something, staying permitted, a permitted use. So we really don't understand either why the bulk controls even come into play. This kind of spins back to all the other several cases Mr. Linder and I have presented. If you're changing the use to something that's permitted, how can you change the condition of the building? I would also note too, just real quickly, this wasn't refused for lot area, which isn't large enough. It wasn't refused for lot frontage. It was just for the side setback. And it's an odd number, 290 feet. So we're asking, the city wanted us to ask for a variance for a 290-foot side setback. And that's all. We don't even understand why we need to be here and going through all this process. It's a permitted use, changing to another permitted use, which we believe is not a change in use, and there's no change in the footprint or the size of the building. In lieu of that, too, we would also reserve the right to come back and ask for a variance if necessary. This is kind of the process we went through before. What we're trying to illustrate is there's a much simpler way to do this. So that's what we're asking the board to consider, that even though now, and we just got the document just as you did just a few minutes ago. And I think another thing I'll allude to also, the Board of Zoning Appeals had a different opinion than the Planning Commission with the law director's interpretation of ground level residential parking for Mr. Wasserman's building on Stimson Avenue. The board denied the variance. The Planning Commission approved the project. So there was contradiction. You had three planning commissioners that disagreed with the law director's interpretation that the board had affirmed. So this is not, I appreciate the opportunity to speak. This is not outside the realm, of consideration. And again, it's something that, maybe the planning commission should look at, something to clarify this a little more. I would contend, that it does need the code needs an extensive review of all the types of facilities that are now regulated by the state, because I'll just give you a real quick example and then I'll quit and Mr. Linder can come up. The state of Ohio actually says that zoning cannot be used to prohibit a child care facility in a residential neighborhood. That's a specific state law. And it's one that I looked to see if there might be a similar state statute for this. There is not. There is not. So you do have to have a local zoning review. But what I would contend is the Athens City Code needs an extensive update as it applies to serving the needs of people with disabilities, including being disabled from drug and alcohol use. Thank you very much. I can answer any questions if you have.
Any questions for Mr. Pearson? No?
Thank
Okay,
you.
sir, you may come to the podium and
My name is Don Linder. I live at 40 Stroud's Run Road, and I'm just going to create a simplification of this. I'm not a, per se, code expert, but the reality of it is, as Steve said, that there's no change of use of this facility. You're using it for residential care with people with disabilities, with problems, healthcare problems, just like the hospital. A hospital will treat people with substance abuse, and they will treat people with illnesses. This facility does the same thing. We cannot, and the law protects from distinguishing disabilities. You can't say they're mentally ill, that you can't say that they are physically handicapped, and you cannot distinguish them. That determination, you can only say there's a disability involved. That's the law. One other product of the law is that somebody that's under treatment for recovery services, if they're an alcoholic, which we have determined an alcoholic is an illness, and you've probably heard that many times on the TV and whatever else. If they're in recovery and they are not drinking, whether it's a drug addict or whether it's an alcoholic, they are protected by the American with Disabilities Act and considered under disability, period. That's the law. So we are treating this facility in the same manner. We're creating residential care, health care for the individuals, and providing a residential setting to get them well, people with disabilities, no distinction. And you cannot distinguish that. You can't say it's people with physical disabilities, mental disabilities, and you cannot distinguish that by the law. I mean, it's just illegal to do that. So I think, again, going back to Steve's representation, that this facility is not changing. We're going to use it for the same particular purpose. It's just a different group of people. And we're just distinguishing it here, which we shouldn't be doing, as one versus the other. If I have a leg missing or if I have a mental illness, you can't distinguish that I have a disability and what it is. So I think that has to be clear. And if we cross that line, we've got a problem. And
do you think you're going to have more clients coming in or less compared to what used to be?
it's going to be, as Echoing Meadows has been, that's considered an interim, residential facility. It's not permanent. They hope, in fact, they have placed these people out into the community. There's a flow of people into that facility, always has been. It could be for a month, it could be for 10 years. They don't distinguish the timeline, but the state does in their licensing. It's an interim sort of housing with people with disabilities, whether mental, physical, combination of them. It doesn't really matter. And they could have substance abuses as well. In fact, I'm sure that's one of the treatments. There's counseling that goes on. There's educational opportunities. They go to Dayhab, the people that were in Echoing Hills. That's the same thing in a recovery center. Same processes. Education, treatment, care, health care. That's all you have to think about. It's one thing, health care. So I've simplified that argument, and I think that the law director argument is incorrect, and I think it does not follow the law.
When I first read the law director's memo, I said, well, that solves the problem. We don't have to do much. But as I listened to and listen to the discussion and look at the document, I began to go back to what I was originally planning to talk about, and that is, what is a hospital? Because, as has already been pointed out, the code does not define hospital. If you look up hospital, it says a hospital. And so you say, you start with B3 since it's in B3. And you ask the question, forget what it says in R3 about residential treatment for developmental disabilities. Can this be considered hospital? Any hospital for human care? So I say, what's a hospital? A hospital is a healthcare institution providing patient treatment with specialized medical care. Go a little farther. Hospitals are distinguished from other types of medical facilities by the ability to admit and care for inpatients. And then finally, we have types of specialized hospitals, which include rehabilitation hospitals. So we ask, is Echoing Meadows a hospital? Under the definitions that we have of hospitals, it is a hospital. And therefore, is what is being proposed a hospital? Yes, again, under the definition of what is a hospital, it's a hospital. And therefore, without referring back to R3 definitions, we would say that a hospital is a hospital is a hospital, and this meets the criterion of a hospital.
So what about an outpatient office or maybe a clinic? Those are under the same definition?
No, you have to have inpatients. That's the one thing it mentions here. You have to have some inpatients. So a clinic, you usually go in and out. So an outpatient clinic. And there's a fine line because there are all kinds of specialty hospitals. We would all agree that Oblenis is a hospital. Is the Castrop Center a hospital? No. It's part of a hospital. In this particular case, my understanding is that there will be inpatients. There will be people who are living there for a period of time while they rehabilitate, presumably. And that falls under the general definition of a rehabilitation hospital.
Well, not only does it fall under the general definition, it falls under the code because the code actually specifies substance abuse.
Yeah.
So clearly, in code, hospitals can include the treatment of substance abuse. So I would suggest that the law director, I don't know the force of the argument that the state of Ohio licenses these things separately, but code seems to say that substance abuse is something that can be treated in a hospital setting. So that would suggest that there is not a change of use. We don't know that developmental disability, which is not mentioned in code, would originally fall under that definition, but we do know that substance abuse does because it's specified.
Good point.
Plus you're seeing
I
the
think she
change
says
of
the
that
state of
too.
Ohio licenses each use separately. That's what she was just really nailing right there.
Well, so much stuff is
State
changing
of
right now
Ohio
with the state. as far as
licenses lots of
classifying
different
drug use.
uses separately.
Yeah, I would like to comment on that. A truck driver has a CDL license. A driver of a car has a driver's license. They're licensed separately under the state of Ohio.
Before you go, we may have some more questions.
Sure.
I have a question. This facility will have all the facilities to take care of these issues of the alcohol and drug abuse compared to a hospital. So are they?
Well, ironically, Oblenis Hospital, Ohio Health Oblenis Hospital, is very excited to have a facility such as this close in proximity to what we call the medical corridor.
Right.
Because they would prefer to refer people to a recovery center rather than taking up bed spaces in a hospital that have greater uses than a recovery center, where they have more immediate and more traumatic needs. And they're looking forward to being able to cooperate. And I have a text from the hospital administration saying that they support this effort and encourage its development. And
So I suppose those are addressed in the licensing at some
Right.
point. John, you have any comments?
Well, yeah, obviously there's a great need for the community for a place like this, and it's near the hospital. Is the security situation any different than with the,
You know, in most recovery centers, there is basically not a lot of security. If you're basically being admitted or being referred to, it's a voluntary act that you're going there in a recovery program. Or it could even be a requirement of the court system. And instead of going to jail for your offenses, you go to this place, but they're going to deem you to be relatively a safe person there and have a chance of a recovery and entering as a productive citizen in our society. And that's really what the definition of recovery is. And, you know, of course, you're going to try to treat people that maybe never can be recovered or changed, but you know, the reality of it is we're trying to create productivity in a society now that we have such an epidemic of opioid abuse and other abuse, and particularly alcohol as well. And again, these are considered illnesses in our society. Whether you agree with that or not, it's, you know, that's the definition. And an alcoholic, it's an illness, you know, and some people may not agree with that, but that's the definition in the health industry. So we're basically treating people with illnesses in a healthcare facility.
Is disability an illness?
Yes, is actually an alcoholic. Is
No, I'm talking about the previous use, which was taking care of the disabled people. Would that be under the illness?
If you have a disability, you could have an illness as your disability. You could have a mental illness and be considered disabled. You can have a physical. You can have even a biological illness that doesn't allow you to be able to go to the restroom, that you have certain physiological problems. Okay. And again, we can't distinguish. The law does not allow you to distinguish between disabilities. You are a particular person who has a particular problem, you know, is defined as being disabled due, you know, to the glossary of definitions. But we can't distinguish, well, he's mentally ill, he's, you know, he's crazy or this or that. We can't distinguish that, even though we do, but we're not allowed to, you know, according to the law. And going back to what Ed was saying, that the purpose, and most recovery centers are going to have people there for 30-day programs. They're going to be in a residential setting for a 30-day program. They're going to be in the bed, in the hospital setting, under treatment with a physician's supervision to help them recover through a step program. You know, and it's generally a 30-day program. And then they're, you know, hopefully they go into the next step of recovery outside as an outpatient, whether it's there or someplace else that they might be participating.
All right, thank you, sir. We don't have anyone else on the floor, but I'm going to go to the code office. Any general comment or any opposition?
Yes, I do. As much as I can appreciate Mr. Pearson, Mr. Linder's description of a hospital, which everyone seems to agree with what the definition of a hospital is, I do not deny that definition. But the argument here is not the definition of disabled or mental retardation, or what we're describing, what we're looking at here is the use of the facility. As the document's all prepared, and even according to the county property record card, the Echoing Meadows is considered a nursing home. And also the nursing homes, much like Echoing Meadows in the residential areas, they go out to the hospital for treatment. They go out to the hospital for treatment. They do not stay there for treatment. They may have someone come in for minor stuff, but any other treatment, they go to the hospital, as everyone has described. And the code, it mentions the hospital, and it mentions substance abuse, which is what a recovery services provides. Okay, so that's where we address it's a different use.
So the Echoing Meadows, do they not have no overnight facilities?
Echoing Meadows was a long-term care, much like the ones that are out in the residential areas now, just like Mr. Linder said,
Okay.
that we have approved. Because there's a law that states we cannot approve that, okay? But what we've got here now is a change of use. And again, We are focusing on the change of use, not the fact that we are trying to distinguish between developmental or whatever other disability there is. It's the change of use of the facility. That's my 2 cents.
Yeah, sure, yes.
I'd like to rebut that frankly, going back to that is a residential healthcare facility, and there are many different types, and it's permitted in this zone, so I don't think you can distinguish one versus the other. You know, it's got beds, they're there for residential healthcare providing, and yes, the state of Ohio does license things, you know, differently, but for that zone, it doesn't matter. Those are permitted uses, and in particular, substance care is a permitted use in that zone.
I'd just like to add 2 things real quickly. If the board does not agree with Mr. Linder and I that this is a permitted use, there's no change and the permit should have been issued, we'll be back to ask for a side setback variance for 290, for whatever the footage is, where 290 feet is required. Just seems like too much of a drill to actually go through. And again, well, I was thinking too, when Don was speaking, there are people who start out because they've harmed themselves, let's say, in some way, and they end up in Oblenis Hospital. A lot of those people leave the hospital and they're transferred right across the way to the Athens Behavioral Hospital. Just like someone who might be transferred from Oblenis might be then transferred, after state review, to a drug and alcohol rehab. It's just terminology. Is it really a hospital? Is it human care? Is there really such a distinction between these uses that it requires some kind of variance? And essentially, the only variance we were supposed to be asking for was a side setback variance. I mean, there just seems to be an easier way to do this, so we appreciate your attention. Thank you very much.
Okay, one final questions for the code office I have. And then is that, let's say they come back for the variance. So all this discussion about the use goes away?
In what way does it go away?
What way does it go away?
No,
we're addressing the use.
that's what this is based on,
No,
is
no,
we
I-
considered
I
it a
know,
change
no,
of
no,
use,
no.
so.
What I'm saying, if they
But
come
both
back-
uses are allowed.
If they come back for the variance, the only issue then would be the setbacks, right?
That's correct.
That's correct.
That's what I'm
correct.
saying. So whatever
Yeah,
we're discussing
correct.
about the use will not be discussed anymore.
That's correct.
Ah,
This
that's
could have
what I
been
was-
simplified if they would have just came back for the setback.
Yeah.
We're not saying
Yeah.
that the new use is not allowed. Both uses are allowed. We're just simply saying there is a change.
Change of use.
That's
what I-
That's
yeah,
it.
That's
Which
what-
requires a
that's
setback,
interesting.
correct?
Correct.
That it requires that
So it's going from a
criteria.
residential healthcare facility to a
recovery.
center, hospital recovery center.
Right.
Okay,
Can I ask the opponents a question?
sure.
So did you know that? I mean, did you realize that you could have come for the setback variance without getting into an argument about change of use?
Yes, we did know that, and we felt that, one, that would be an elongated process, and you could vote against that. And we felt that we needed to distinguish, basically, that there is no change of use from a moral and an ethical perspective.
If I may ask Mr. Linder, since he's representing Mr. Funk, does Mr.
No,
Funk?
I'm representing Echoing Meadows. I'm not representing Mr. Funk. Because
Do you have
Echoing Meadows is selling this
affidavit?
facility. I am their real estate broker.
Where's that?
And if this sale does not go through because this occurs, then that creates harm to them of a significant dollar value. So I'm representing them in presenting their interests in what I believe would be their presentation of what is a disability and what is not. They have been in this community for 50 years, representing people with disabilities and housing them and treating them in a healthcare facility. They chose to allow a recovery center here because they felt that was a continuum of their use of that same facility. The facility does not need any modification at all to allow for recovery services. And in my mind, the definition of non-change and be able to use a facility in an existing configuration defines a no change of use.
Okay, so we want to clarify that you were speaking as a citizen, but not as a representative of Mr. Funk.
I'm representing this.
Right, I'm representing the owners of the facility.
Okay, very
Okay.
good, thank you.
If I may ask Mr. Pearson then, representing Mr.
Mr.
Funk.
Pearson, could you come to the podium, please?
If I may ask Mr. Pearson, do you know of any knowledge that Mr. Funk or there will be any other additional building added to the existing structure that's going to be sold?
As far as I know, and the way this was presented to me, was that it's just a change from one type of hospital setting, facility, residential care facility to another. At this time, I'm not aware of any additions to the building, additional construction. Anything like that would need additional review and approval from the city. Essentially, when you go to 2 or more buildings on a lot, you're talking about a planned unit development, which would have to go to the
I'm not
planning
addressing that,
commission. for
attached
review.
to the existing facility.
Addition to the existing facility,
The
not that I'm
existing
aware of.
facility. Okay, that's all I have.
No.
Thank you.
Unless there's any questions, we're going to close the discussions on the floor. And I think we need to make a motion.
But what would the motion be? Is it for the setback or the?
Just read as it is, and then I will clarify.
Excuse me, Mr.
Is it
Thomas?
interpretation?
Oh,
No, the way, whoever does the motion, the way I would phrase it is, I move that the board agree with the
Yes.
interpretation. And then you vote yes, you do agree, or no, you don't agree.
That's it. That's all you have to do.
I'm gonna be honest.
Okay.
I'm
Kay, you
kind of
want- I can
I'm
do
kind of
it.
lost
Let-
with the
Shall I do it?
setback versus the change of use.
Let's Kay.
Yeah.
I move that the board agree in case 17-241, 319 West Union Street, Zone B3, that the board agree with the interpretation of the code office that there is a change of use from residential services for special needs individuals to drug and alcohol recovery services. So that means if you disagree with all of this, all
Well,
of-
if you agree with the code office or the law director, you raise your hand.
right.
If you don't agree, you don't raise your
Right.
hand. If you abstain, you don't raise your hand.
Is there a second?
I second.
Are we ready to vote?
I'm still thinking.
Okay.
Yeah. This is
This is one of those where it's already been pointed out, the code is woefully inadequate
Yes.
in providing guidance. Because one section is under R3 and the other is under B3. And while B3 references everything back to R3, technically speaking, and I'm sort of thinking out loud right now, that, and this is what I don't know, when the original building was it built under the R3 definition, even though it's in the B3?
We have a copy of the 1978 building permit.
Which you guys have.
Yeah, and it says to be used for residential care facility.
So that sounds like the R3 definition.
Would you mind reading the last paragraph of that permit, please?
The note.
The note?
The note, yes.
Permit for residential use does not include a home occupation, boarding or lodging house, or any other commercial activity unless specifically authorized above.
Unless specifically authorized above.
Okay, I'm ready.
Okay. All those who agree with the code office and the law director as stated, please raise your hand. And all opposed? You don't vote tonight.
Sorry about that.
So I guess we have 4-1. For any reason,
didn't
so,
re-
yeah.
you abstained?
Yeah, we have 5 days to change our minds, right? I'm sorry. I was gonna be abstain, I'm sorry.
3-1.
Yeah, I didn't mean to raise my hand. I abstain, I'm not.
So we're 3-1-1,
3-1-1, yes.
whatever that
Yeah.
means.
Because I am not exactly sure on all the rules and the laws. I need more time to study those. So I'm not gonna vote either way tonight.
Okay.
Are we done?
So this,
Now, my question is, what does that really mean?
it means if they resubmit, we'll approve it.
Okay?
The board has, the code says the board has 5 days to issue a determination.
Right.
Is what it says.
Right.
So,
Okay, we have the disposition of the minutes from September 12th, 2017. And Lisa, you're the only one who were not here. The rest of us in here. Did you all read? Okay, do we have a motion to approve?
I move to approve.
All in
Second.
favor? Okay. And any other discussions? No?
No.
Okay, we adjourn the meeting.